Good afternoon, everyone. I hope we are properly connected. I'm going to go ahead and just make sure that we are actually connected on all platforms. So you should be able to see this if you're tuning in from LinkedIn, YouTube, Instagram. So that's 3 different places. For those of you who are new to Alphonse Latham LLP, we are a law firm based out of the GTA, where we practice in various areas. Those areas include employment law, which is my practice area, immigration, as well as entertainment. So when we're thinking about entertainment law, we're really discussing intellectual property. But today's meeting really isn't about that. Today, we are here to discuss discrimination claims and what to do when you receive a discrimination complaint. So I'm going to go ahead and give a few moments for everyone to log in to make sure everyone is hearing me well. For those of you who are in, can you let me know if you can hear me? If you can hear me, just go ahead and give me a thumbs up or let me know in the comment section. That will really help me ensure that we are properly connected. So I'll just give a few moments for that. Anna Jones says, loving the green. Thank you very much. I really do appreciate that. Can everyone hear me on LinkedIn? Can someone let me know if I'm well connected on LinkedIn and that you're able to hear me from there? Just want to make sure that we're all good. Okay, perfect. Catherine says audio is good. For anyone who's tuning in from Instagram, are you able to hear me? Just want to make sure that we're connected there as well. Okay, so I'm not seeing any Instagram folks. I'm going to see what we can do on the back end to make sure that this happens. Bear with me while we make that happen. Okay, so I think we are connected through Instagram. We should be fine there. I'm going to try again and see if this is going to let me connect, and then we'll proceed with today's conversation. Awesome. I think we're fully connected. Okay, so let's talk. For those of you who don't know who I am, my name is Lavinia Latham. I am a partner and workplace investigator here at Alphonse Latham LLP. Today's conversation really is centered on those decision makers, those individuals who are sitting at the tables of many of your workplaces. If you are an employee, sitting at the table and receiving these complaints. So a complaint comes in, now what? It's stressful. I get that. And there's definitely probably a lot of emotions going through your head. People are concerned about, hey, what do I do to not make this situation grow into something that's even bigger than it has to be? And that is fine. That's why you're here today. So essentially, a discrimination complaint comes in and you don't know what to do. The first thing that you should do is make sure that you receive that complaint in writing. So you want to get the who, what, when, where, why, and how of the situation. And you want that documented in writing so that you can go ahead and make sure that you're able to properly follow up. Now, before I continue, I do want to preface this conversation with the following. This is legal information, not legal advice. If you do have a particular situation that is gnawing at your mind, you're worried, you're stressed, you don't know what to do next, and you're just looking for information, today is very general in nature. But anything that's going to be specific to your circumstances, please feel free to reach out to me directly at Alphonse Latham. So there is a QR code that's going to pop up on the screen. I'll leave it there for those of you who are interested in engaging further. But let's pop back into this discrimination complaint that we've received. So you got the information, you likely have the 5 W's, and now you're wondering, what do you do next? Well, in Ontario, there is a duty to investigate. So once you receive that complaint or you become aware that there has been a complaint within the workplace environment, the next thing you want to do is engage in a workplace investigation. Now, that workplace investigation, we're going to talk about a little bit further, specifically what that's going to look like, but we're also going to discuss the things that you should not do. So you know that you should do an investigation that is pursuant to the duty to investigate here in Ontario, but what you should not do. So you don't want to try and tell the complainant that what they're going through is not necessarily real. So let's give this some real facts, some real people. Jill is complaining that John has subjected her to racism. if Jill is saying that John has subjected her to racism, you don't want to be going ahead and making it seem as if what she's experiencing is not necessarily real. You also don't want to receive that complaint and do nothing about it, in the sense of getting the information, getting the 5 W's, and then going ahead and essentially doing nothing. That, while you might be confused and it might feel as if, there is a concern about, hey, what do I do next? I don't know what to do next. The best course of action is to lean into some type of action. So acknowledge to the complainant that you've actually received this complaint and that you're going to take it seriously as an organization. And then the next step to follow is to schedule some type of a meeting with that individual to hear a little bit more about whether or not they want to move forward with the complaint, and ideally what is the situation? What is it that they're looking to get from this? Sometimes individuals will complain about something and then not necessarily have an intention to move forward. They just want to put the employer on notice, which does raise other duties and legal responsibilities. But in other circumstances, the individual actually might want you to step in and do something. So say Jill wants the organization to step in and do something. At that point, then we want to go ahead and consider hopping into a workplace investigation. So let's talk about the workplace investigation. We've got about 45 or so minutes left. I'm going to leave some time for some questions at the end. But together today, the hope is that we can discuss the following 3 goals. Number 1, when internal investigations work. Number 2, when those internal investigations fail. We're going to talk about how to mitigate those risks as well. So the legal duty to investigate, does anyone know what that is? If you know what that is, let me know in the comment section. But for those of you who might not know what it is, and this is very important information for both employers and employees, but essentially the duty to investigate is part of a 3-pronged system. So most laws, as it relates to employment law, tends to touch upon these various different pillars. Let's call them pillars. So there's the Occupational Health and Safety Act, there's the Ontario Human Rights Code, and then of course there's the common law. So the Occupational Health and Safety Act is really stipulating that employers must investigate workplace incidences and complaints to ensure workplace safety. Workplace safety speaks to psychological safety. It also speaks to physical safety. But of course, if you're dealing with a workplace investigation as it relates to discrimination, this is more of a psychological safety situation that we're trying to ensure remains intact in the workplace environment. Number 2, the Ontario Human Rights Code. So organizations must thoroughly investigate discrimination and harassment complaints that touch upon any of the protected inherent characteristics under the code, under Section 2 of the Ontario Human Rights Code. So that's things like race, color, ethnicity, sex, gender. These inherent characteristics are constantly growing. The common law is constantly expanding what is to be protected under the code. But specifically, generally speaking, we do have things like race being a part of the protections under the code, as well as various different other areas that you can definitely check out by looking and simply Googling the Ontario Human Rights Code and then Section 2. That should be able to provide a little bit more information about the inherent characteristics. If you are thinking, hey, this issue that I'm having at work, does it touch the code? Definitely reach out and we can chat. Common law. So the courts affirmed employers' duty to conduct proper investigations that are reasonable and procedurally fair in adequate processes that create liability. So let's talk about workplace harassment investigation requirements pursuant to the Occupational Health and Safety Act. To protect workers from harassment, employers must do the 3 things. Conduct appropriate investigations into all harassment incidents and complaints, provide written results of the investigation to both the worker who reported the harassment and the alleged harasser. So that's kind of going earlier to what we talked about, whereby you really want to take this thing seriously and convey and communicate to the complainant that you are taking it seriously. And number 3, to review the workplace harassment program at least once a year. So these are some of the requirements that you can see underneath the act itself. In terms of excuse me, when internal investigations work, it works in very specific situations. So for example, if there's been a minor policy violation, if you're looking to reduce costs, if there's low reputational risk, there's no power imbalance, those are good circumstances where it could be a good idea to do an internal investigation. And it's certainly very useful and very effective for an organization in those circumstances. But there are pitfalls. So pitfalls of internal investigations include perceived bias. So for example, if you're in an organization and there aren't a lot of people there at that business, at that place of work, the internal investigators could be perceived to have a relationship with the parties. So think, HR, a manager, maybe one employee is more popular with the HR or the manager than the other employee. That can raise allegations, even if they're not true, that the investigation itself is in fact biased. Number two, process deficiencies. So inadequate documentation creates legal vulnerability. When you're conducting a workplace investigation, it's a very sensitive process with very high emotional stakes involved. And so if you've got a situation where there's high emotional stakes involved, you really want to ensure that the evidence, that the documentation, the record keeping of the various different judgment calls that have been made, the process, all of these things need to be intact and available if necessary to defend against a challenge down the line before a court of law or a tribunal. Number three, internal investigations could suffer from litigation risk. So, in Marintet in Canada, a little bit of case law here, we won't do too much of this, just to make sure everyone's on the same page here. But the court in that particular case rejected a flawed investigation. And so that case told us that when we are doing workplace investigations, we want to make sure that those investigations are being conducted in a fair, procedurally fair way that is defensible before a court or a tribunal. So having an understanding of how the law works and how the law will handle this is going to be very important as it relates to being able to defend that investigation. Expertise gaps. So HR teams often lack specialized investigative training, and it's really important that investigators are able to defend and understand and apply their investigation processes in a uniform way. It's not about the process being specifically prescribed by the court, but that process does have to be defensible, and it does have to be in a way that others can understand and can follow along to determine whether or not that investigation process was actually executed fairly for all parties involved. So we won't do the poll today, but think to yourself, what's the biggest concern you face as a leader, whether you're in HR, union, with internal investigations? Is it a fear of bias perception? Is it a lack of experience? Is it a lack of time or resources? Or are you not sure when to escalate? If we had some time together more directly, we'd certainly engage in this process, but for the purposes of today's webinar, we will skip past that. So we know the benefits and the pitfalls of internal investigations, but what about an external investigation? Well, these are the circumstances when you might consider external, which is precisely what we do here at Alphonse Latham. Number one, significant power imbalances. So if you've got maybe a high-level executive who's being brought forth as a respondent, and there's maybe a junior level staff member who's holding a high-level executive accountable for perceived allegations and actions, then in that circumstance, it might be necessary to engage an external investigator because that high-level executive has a heightened likelihood and proximity to the decision-making process that could raise allegations of bias. Number two is if it's serious legal allegations. So think sexual assaults, think some racial slurs were used, anything that's affecting personal bodily harm, any of those things are going to rise to the level of serious legal allegations. And all of this is on a it depends level. So us lawyers, we are very, we like to say it depends. And a lot of people don't necessarily want to hear it depends, but it truly does depend on the circumstances. Not every single situation is the exact same. Number three, media attention risk. So typically speaking, yes, we're in a climate where EDI, that's equity, diversity, and inclusion, is less of an interest as it was, say, closer to 2020 post George Floyd. However, organizations still don't want to be the face of discrimination, regardless of which racialized or marginalized group is currently asserting or alleging that they've been harmed. And so in order to kind of protect against some of that media risk, that negative media risk, it's advisable to engage in an external investigation. The next one is systemic issues. So if you're in a business, you're in a workplace environment, and this allegation has been rising up over and over again, it might be worth it to engage in an external investigation process so that, amongst other reasons, is whatever the outcome of that investigation might be, at least you can rely on the fact that you engaged in an external investigator, and not an internal investigator. That perception is very helpful with systemic issues, and it can help quell some of the, stakeholder noise around whether or not this investigation was even fair. So that's a really important reason why you might consider bringing in an external investigator. So, these things are expensive. That is true. But why would an external investigation actually even be worth it? Well, there's the legal defensibility. So courts typically do give more weight to independent investigations as opposed to internal investigations. And the reason why they do this is because, typically speaking, an external investigator is going to be a lot more removed from the issues, removed from the parties, and really able to satisfy the court that bias was not a part of the decision-making process. Number two is enhanced trust. So employees, the parties to the investigation, if they feel like that process was fair, chances are likely you'll be able to have a more smoother investigation. And regardless of what the outcome of the investigation is, at least there's not this perception of unfairness because it was internal, and there might be some additional allegations floating around that the results of the investigation are what they should not have been. Parties are also more likely to fully engage and accept the findings when they are in an external investigation versus an internal one. I can tell you super quickly a very quick story. I have been in situations across various different companies and organizations where an internal investigation was conducted. And of course, here at Alphonse Latham, we do external investigations. But I can tell you, being on both sides of the coin, typically speaking, parties are more willing to engage and trust the process when an external investigator who nobody knows is involved, as opposed to someone who's internal, who you walk up and down the hallways with every single week, or maybe even do lunch with sometimes, and is internal to the organization. Number four is risk mitigation. So it protects organizations from procedural fairness and reasonableness challenges, which we've discussed, and it creates distance between the company and the findings. So another quick story that I can share with you in today's webinar is the fact that, typically speaking, it's an investigation, right? Not everyone's going to be happy. It's one of those situations where you cannot be Switzerland. You do have to choose who is going to lose, quote unquote, lose, their version of events as it relates to putting that in front of the investigator, and whose story is going to be, supported by the evidence, supported by consistency, all the things that we look for as investigators, which is another conversation related to credibility and reliability, but is outside the scope of today's conversation. Fourth, and definitely not least, is specialized expertise. So trained investigators follow best practices. We're held to a standard where we regularly engage with each other. As investigators, we want to ensure that our processes are defensible. And so that continued learning in that sense is very important. If you go internally, yes, you have HR, and yes, individuals are trying to do their very best, but of course, that is not the bread and butter of the organization. That is not their day-to-day activities, their day-to-day operations. It's going to look a lot different in terms of process internally versus externally. Also, having a legal background really does ensure a solid process. It helps to have an individual who's retained as the external investigator, who understands how evidence works and what's reliable evidence versus what's not reliable evidence, what's a credible witness versus what's a not credible witness. These are the kinds of things that an external investigation can support. So that you've got this big decision in front of you. You're deciding, hey, do I go internally or do I go externally? But how do you even vet a good investigator? Well, you follow this 4-step process. Number one, you want to verify their legal training. And I will say you want to verify their legal and or professional training. So there are investigators, workplace investigators, who are not called to the bar, but they are operating and acting as a workplace investigator. That's perfectly fine. It's very much legal. It's something that happens all the time, but you want to make sure that the person who you are ultimately choosing to do the investigations work is aware of the various different legislations, common law, those kinds of things that are at play, and that you ensure that who they're holding themselves out to be, they actually are. Excuse me. Second, you want to assess independence. So confirm there are no conflicts within your organization. You want to make sure that whoever you're appointing as the workplace investigator does not know the parties. Yes, that will result in an unfair or procedurally unfair workplace investigation if down the line it's found out and it becomes revealed that the investigator actually knew some of the parties. That would be problematic. So if you are on the side of hiring an investigator, you want to make sure that that's not at play. Number 4, evaluating the court experience. So choose investigators who have experience litigating similar matters. And that's for lawyers, of course, because only lawyers can litigate, with the exception of paralegals. But again, that's another conversation. Number 4, consider trauma expertise. So sensitive investigations require trauma-informed approaches. You want to look for some specialized training. So oftentimes individuals who are navigating very sensitive, emotionally high-strung situations might be subjected to further traumatization through the process of the investigation. We want to make sure that that's not happening. So be comfortable with doing your research to make sure that whoever that workplace investigator is, they do have a trauma-informed approach to the work that they do. And the parties that you're putting into their care, since this process is highly independent and separate and distinct from a company, you want to make sure that that person is doing so in a way that's not affecting further harm. Another poll that we do not have time for, unfortunately, so we will move along. However, on your own hand and on your own time, does your organization have a standing list of approved external investigators? The question is yes, we use it regularly. B, yes, or the answers rather. B, yes, but it's outdated. C, no, we decide ad hoc. Or D, not sure. I pose this poll to you to really just get you thinking about what your process at your organization looks like. If you're the employer, you should know, what's going on as it relates to these complaints. You want to be prepared before the complaint arises. And as employees, you want to know what your process is at your organization if, in fact, you are going through a circumstance that requires some support. So pop quiz case study time. Sarah Monroe, HR director this is another, think through it on your own if you've got the time and you're interested. But Sarah Monroe, fictitious, of course, HR director at Tech Forward Inc., receives a racial discrimination complaint from VP of Engineering Drew Smith against junior developer Avery Morgan. Drew alleges Avery made racially insensitive comments during code reviews and team meetings, creating a hostile environment for him and other racialized team members. Power dynamics. The senior leader is filing against a junior employee, creating a reverse hierarchical complexity. Potential media risk. Tech Forward recently announced diversity initiatives in industry publications to mixed reviews. So some people were very happy for this and others were very unhappy about it. And then another thing to consider is legal considerations. The company could face further liability if the investigation appears biased. So this one, I think we have a little bit of time for. Let me know. Would you think that this would lean in the direction of an internal investigation or external investigation? Let me know in the comments, either down below, maybe you're on Insta and you can type it in. I would love to know where your thoughts are on this. Susan St. Marseille says, is the presentation frozen for anyone or is it just me? I hope that it's not frozen for everyone. Please, if you can see it. Okay, so Jean-Michel, hello, says seems better now. Okay. So since we're all on the same page here, what do we think? Do we think that this is going to be an internal investigation or external? Let me know in the comments. Okay, so I see someone on one of the Instagram says it's going to be external. And yeah, you would be correct. So, I mean, given the various different things that are at play here, it would be external in nature. External investigations reduce risk. So this is where you're creating that distance between the organization and the findings, which that separation certainly protects against procedural fairness and reasonableness claims and allegations. Credibility matters. External investigators bring specialized expertise, as we discussed, in legal knowledge. Escalating complex cases when power dynamics are reversed or media scrutiny is likely, external investigations become essential. And finally, choose investigators carefully. Vet for legal training, independence, courtroom experience, and trauma-informed approaches for sensitive cases like racism and discrimination. So we are here for about, oh, I see a LinkedIn user says, I'd say it's best to hire an external. Yes, absolutely. Susan says external, Jean-Michel says external. Thank you for confirming that we are all good. So that really concludes the piece regarding external investigations and how to respond in a legally defensible way. The next piece that I really wanted to cover is ensuring that, once you do have your report and you do have your findings, then what? So in those particular circumstances, now you need to decide what you're going to do about the issues. So are you going to end up terminating someone? Is there going to be some corporate training? Is there going to be some type of a restoration happening? What is going to be happening next? Well, we want to root what happens next in creating an environment in the workplace that is going to foster restoration and foster healthiness for all of the individuals involved. It's very important when an investigation is moving forward that things are taking place in a way where you can actually restore. So one of the most important things related to investigations is the fact that reprisal is absolutely illegal. It's not defensible at all. So individuals who engage in the investigation process, whether that be the parties, whether that be witnesses, they should not be subjected to any consequences. In law, we call that reprisal because they decided to participate. There also shouldn't be any consequences outside of the actual complaints process. So if this is an individual who it's their first time having an allegation and a finding against them, that organizational response might look different as opposed to someone who might be a frequent flyer with discrimination complaints, right? There needs to be a graduated approach. So there are various different circumstances that require, there's a lot that requires that could rise to the level of a termination. And there's a lot that could simply rise to the level of a write-up. And those are the kinds of circumstances that we can certainly support organizations in determining what is most appropriate given the circumstances. So in terms of next steps and a conclusion, thank you very much for joining me today. Let's stay connected. If you're interested in a consultation, if you've got something on your mind and you wanted to dive into a little bit more deeply, by all means, check us out at alphonselaw.com. You can also go ahead and use your device to grab that QR code and we can engage in a conversation. If you are watching today's session, feel free to email me directly at lavinia.latham@alphonselaw.com. Happy to chat with you. We can, schedule a quick 15-minute coffee chat to discuss your organization's needs, and we can go from there. In terms of, finding us on social media, of course, we're here on LinkedIn. We're also on YouTube. So shout outs to the YouTube fam who are engaging in today's session, and also, of course, Instagram. Thank you very much. I really do appreciate your attention to today's topic. We are striving to do more webinars in the future and to be here more regularly. So do keep an eye out on Alphonse Latham's main LinkedIn page for future webinars, either from myself or from my partner, Carl Alphonse, on the topic of immigration. And there might even be some entertainment as well. Thank you so much. I really do appreciate your attention this afternoon. It is now almost time to go home, rush hour here in Toronto. And if you are on the east side, I wish you a safe and enjoyable journey back home. All the best. See you in the next one. Bye-bye.